Hi, Peter Skwirz, Assistant Solicitor for the town of East Greenwich. Our office reviewed this application with GZA Geoenvironmental Engineering. East Greenwich's interest is prompted by the siting of the project. While the proposed facility is in an industrial zone in West Warwick, it is directly across the street from a residential zone in East Greenwich. The General Assembly created a mechanism for addressing this type of interlocal planning concern. Unfortunately, that mechanism has not been followed in this case. As stated in RIDEM's Notice of Intent to Approve the license, review in this is governed by Title 23, Chapter 18.9, Section 9 of the Rhode Island General Laws. The first part of that statute, subsection A1, lists a number of items that an applicant for a solid waste management facility must submit with its application to RIDEM. That part of the statute says, quote, "The applicant shall also submit simultaneously with the application a certificate of approval of the proposed site issued by the State Planning Council," end quote. The State Planning Council, quote, "shall only approve a site after great weight has been afforded to the detrimental impact that the placement of such a facility shall have on its surrounding communities, and only after evaluation of alternative sites," end quote. Also by statute, the State Planning Council, quote, "shall not issue its certificate prior to publication of public notice and the expiration of the public comment period regarding the proposed site," end quote. We confirmed in an email from Meredith Brady, the Secretary of the State Planning Council, that the State Planning Council never approved this site and was never asked to approve this site. It did issue an internal letter to the Rhode Island Industrial Facilities Corporation on state guide plan consistency, but that letter wasn't issued after a public notice and comment process, and Ms. Brady stated unequivocally that that letter was not an approval for the site. Therefore, under the statute, RIDEM should not be considering this application. Prior to the hearing today, we brought this to the attention of RIDEM and MedRecycler. We were told that even though we all agree this statute governs MedRecycler's application process, that the language I just quoted only applied to landfills. I'd encourage anyone attending to read the section of the statute I quoted, and you won't see the word landfill anywhere. What makes that interpretation particularly strange, if you go to the next two statutes in that chapter, Rhode Island General Laws 23-18.9-9.1 and Rhode Island General Laws 23-18.9-9.2, those statutes do place additional requirements on landfills, and those statutes use the word landfill repeatedly. So the General Assembly knew how to say landfill when it wanted to say landfill. The General Assembly didn't say that State Planning Council approval is limited to landfills. The executive branch of the government doesn't get to rewrite the statute that the General Assembly wrote. It's Civics 101, the legislature writes the law, and the executive branch carries it out. The public, justly, has significant siting concerns regarding this proposal. It doesn't engender public confidence in the review process or in the government generally if the reviewing agency is willing to tie itself in knots to avoid the review that the people's elected representatives in the General Assembly required. The jettisoning of State Planning Council site approval is just one in a number of ways that the review of this proposal has been unusual. We explain in further detail in our written comments we've submitted, which are on the town website. But this issue in particular is illustrative of the fast-track, results-oriented process that MedRecycler has received up to this point. I would request that the town would request that RIDEM proceed no further with its review until all of the concerns outlined in our comments are addressed through the statutorily mandated review process. Thank you.